All right, folks, here we go. So today we're going to review the equity purchase agreement. This contract is to be used when a home has equity and we're buying it subject to the existing liens, right? And so subject to the existing liens basically means that we are going to be um, taking over the existing mortgage they have. And what's going on with this thing? And then paying a reinstatement. Okay, that works. Paying a reinstatement to get their mortgage back up to date, make their payments for them, and then eventually after we purchase it, fix it up, and resell it, that the loan gets paid off. Okay? So we'll go through this section by section. Everyone can see the contract?
Yes.
Okay.
Yes, sir.
First section is just the date of the contract. Second section is the buyer name. This is my LLC that I've been using for the last 8 years or so, and our address here on Moreno Boulevard. And then next section is the property that we're discussing, street address, the APN, the assessor's parcel number, and then any personal property as well, right? If they're leaving behind a car, or if we say they're going to leave behind the appliances, or if there's solar, that they're going to leave behind the solar, anything else that makes sense to keep behind on the property, that would be potentially up for negotiations on, oh, I didn't know you were going to take that hot tub or not. You know, I thought that sauna was fixed and you took it. So in consideration, section 1, buyer agrees to pay the seller as follows. Total consideration to be paid, including cash payments. So this is the total amount that we're paying, which includes the payoff amounts for any mortgages or any liens against the property, right? So in this, we can kind of run an example. I'll type some numbers in here. Let's see if I can do edit document. Make this a little bigger. Okay, so we'll plug some numbers in just so you guys can get a feel for it. So let's say we're buying a house for roughly $400,000. Okay, that's the total consideration. This is about, typically when I'm buying a house that could sell for $600,000, I don't want to pay more than $400,000 for it, because that gives me enough spread to fix it, which is anywhere from $80,000 to $130,000. Enough money to sell it, closing costs, selling costs, commissions, utilities, tax payments, etc., and then still net something to keep our business going, right? So that's the total consideration. That should equal all of the other numbers in section 1 added up together, right? So at section B, it says, at the expiration of the cancellation period, and this is something we'll discuss in the contract, is that when a buyer or seller agrees to sell a home while they're in default, which means that after they've got a legal notice of default filed against their property, they are allowed certain rights, which includes, most importantly, a 5-day right of rescission. With a typical real estate contract, if a seller agrees to sell you their home, there's no right of cancellation. They can't say, oh, sorry, I changed my mind. It's too late. You're in a contract. You have to sell us the home. In this case, they have 5 days to say, you can think about it. And then after 5 days, then they have to sign the contract if they haven't canceled in that period. So at the end of the cancellation period, typically in my negotiations with them, I'll figure out how much money they need to move, or we'll figure out other tactics to figure out what that number is going to be. So at the close of the contract and the rescission period is when we have the contract perfected, which means that they're signing a grant deed and they're signing over ownership of their interests of their property to me, which I then record with the county, which makes Covalum LLC, my LLC, the legal owner of the property, right? So let's say this number is going to be $10,000. When they sign the contract after 5 days, we're going to pay them $10,000. Keep that in mind. This is just a hypothetical situation. Possession, the two biggest terms I negotiate when dealing with the distressed seller are how much time do you need and how much money do you need, right? And so with that, they might say, we're ready to go right now. Cool. So after day 5, maybe they're ready to move right on day 6. And so this number might be the same, but I like to keep them as separate, because they might say, oh, sorry, I didn't realize that it's going to take me another week to move out. Well, I want some protections in my contract because that costs me money. So typically this could be anywhere from 1 to 2 months on average, where someone will say, yeah, buy the house, give me some money, and then I'll move out 1 month later. So let's say it's a 30-day move out or possession period after they sign a grant deed, which would make our company the owner of the property. And let's say that at that point, I'm going to give them an additional $15,000 on the day they move out. Okay. So it says here the amounts by which any recorded. So this number can decrease or increase if the liens on the property are higher or lower than what we had understood them to be prior to executing this contract. Does that make sense? So if I thought that the mortgage payoff was $250,000 and actually it came out to be $240,000, well, that's less that I owe the bank. That's $10,000 more I can give to the seller. And per this contract, I would give that to them, right? Right. So sometimes I'll overestimate the payoff if I don't have a proper payoff statement for my first lien and say, okay, it looks like your principal balance is 249, but there's going to be some fees and stuff. So let's just call it 250. But if for some reason it comes back and they have an escrow overage, and by the time the payoff is all said and done, they only owe 240. Well, instead of $15,000, I'll give them 25, right? On the flip side, if I estimate it to be 250 and it actually turns out to be 260,000 for the payoff, well, instead of 15,000, I just had to pay 10,000 more for their bank. How much money am I giving to them instead at when they move out? 5,000. John's got his hands up. Got it? Okay, so this also can go up or down by depending on any other liens on the property, right? What are some examples of other liens that someone could have on a property?
Tax.
Okay, what else?
Contractors, solar.
Yep. Thanks, Gary. Anyone else? Anyone else have any other ideas of any other liens that'll show up on title? If not, I'd advise you to retake your real estate 101 classes. Josh, Brooke, you know any of these?
Maybe child support? Or no?
Child support, for sure.
Oh, dang.
Child support, especially if it turns into a judgment. Medical
Yeah.
collections can be on there. If you've got a HELOC or a home equity line of credit, solar liens, if you owe solar liens on a property, I don't want to take those over. We got to pay those off. So those are some examples. Okay. Section D, buyer shall take title subject to all recorded liens and encumbrances against the property. Impounds, if any, are to be assigned without charge to the buyer. What's impounds, guys?
Taxes.
Yep. And
Taxes, insurance.
taxes and insurance. So impounds are what the mortgage company calls when they collect on the payment, monthly payment, a small portion annualized over the year, so they can make your home taxes, property taxes, and your home insurance payments for you, right? So when people say that their payments as PITI, that stands for principal and interest, which is your mortgage itself, plus the TI, which is taxes and insurance. So when you're looking at someone's total payment, it's PITI, which is principal, interest, taxes, and insurance. Taxes and insurance collectively are considered impounds or an escrow account with your mortgage company. And depending on what kind of mortgage you have, you can either have the option to have one or not have one. And some mortgages require you to have one. Make sense? So they're saying that if there's a balance there, that amount is passed on to me as well. Okay. So section D1, existing first loan with principal, interest, fees, penalties, and any other charges on the first loan currently due as of the date of cancellation, totaling approximately. So we'll make this kind of simple. Let's say it's just these two numbers minus each other. We're at $375,000 for a mortgage. Okay. It's typically the case is people only typically have one mortgage. Sometimes they have two. Rarely do they have three, but it's not impossible. I've been screwed on one where I didn't have proper title insurance years and years ago. And all of a sudden a silent third decided to record the day before I paid off for the tune of $99,000. And I went from making about $90,000 on a house to losing $9,000 on that house. So that's a $9,000 lesson that I learned. Make sense?
Yep.
Existing second loan with principal, interest, fees. In this case, we're going to say it's nothing. So we'll just put in a zero or, line item that through. Existing third loan, Like I said, rarely happens, but it does happen. Let's put in 0 again. I can look up delinquent property taxes. You guys know where you can find where the property tax information is?
County.
Yep. County assessor's office. You can go right in, type in anyone's address or parcel number and find out if they're making their payments on time. It can be a little snoopy, but whatever. I mean, it's a good way to find out if someone's delinquent is really delinquent. Have they been paying their taxes even? Maybe not. Make sense?
Yes.
Yep.
Okay. HOAs, this is one of the more common things that you're seeing right now as of June 2021, because all the foreclosures with the mortgages haven't come through the system yet. You are starting to see a lot of HOAs that are ready to foreclose because they haven't been making their payments during COVID and all those protections are gone. And guess what? Those HOAs will foreclose on you. So you might think, oh, it's just $300 or $400 a month. And what are they going to do? Well, I tell you what, tack on some lawyer fees of $1,500 a pop every time they talk to the lawyer. That $3,000 or $4,000 fine could be closer to $6,000 or $10,000 now because of all the junk fees they're allowed to put on there. And in California, HOAs are considered super liens. They don't get discounted. They get paid off first and then everyone else gets paid off. Right? Make sense? HOAs need that money to keep their community in good standing so everyone else in the community doesn't get affected because of some people that can't afford to pay the HOA in that community, right? You don't want to have your common area maintenance go to crap because someone can't afford it. You got to be able to get that money out of the equity of the house so you can keep the community looking nice. Some of the other liens we mentioned, medical judgments, collections, child support, et cetera, et cetera. We typically pull title now and we'll get title insurance when I close. So I know exactly what any liens are on there, right? If they have unpaid taxes on other properties they own. But in this case, these are all 0. And as I said, all of these numbers, if there's other numbers here, would add up to the 400,000. In this case, we got 10,000 plus 15,000 plus 375,000. That is $400,000. Make sense? Okay.
Yep.
Section E has a strike through it, but it's possible that you would want to use it. So this is a case where if the mortgage was significantly less, I would consider doing a seller carryback if the seller agreed. And this is kind of, if you haven't looked up seller carrybacks, it's kind of a whole nother lesson on seller carrybacks versus even just the subject to. You can Google some information on it. If there's enough demand, I can do a training on it. But basically, we're giving the seller a note at certain interest rate and saying, instead of paying you cash when I close, I'll pay you off this note when I sell the house, right? So that keeps it so I don't have to put as much cash into the property if they have a lot of equity, right? If they have a few $100,000 in equity and I only want to, pay them $50,000 now and give them $200,000 later, well, I can use this paragraph to say, hey, we're going to do a note for $200,000 at a rate of 10%. And I'll be paying you, pay at the rate of X amount per month, whatever that figure is. So you can get some residual on it, or maybe it accrues and I pay it all off at the end if you don't need the money right away, Mr. or Mrs. Seller. Does that make sense?
Yep.
To be candid, I rarely, if ever, use this money because I just don't want to have money out with the seller and have terms out with them longer than I need to. I'd rather get this all cleared up and done. And last thing I want to do is have a note with someone and then they say a month later, I changed my mind, I want that money. Well, I'm like, well, I have to wait until I'm done. I'd rather not do that. So I typically don't, unless it's extenuating circumstances or a special reason for it. This is a disclosure I mentioned earlier. In the event the face amount of any liens referenced above are less than the amount disclosed by the seller or are non-existing as of the date of the closing, buyer shall pay the difference to seller in cash at the time of possession. So in this case, if this $375,000 mortgage only turned out to be $350,000, good news, I'm going to give you, Mr. Seller, an extra $25,000 at close. All right, that's only the fair thing to do, and I'm all about making fair deals. Okay. Section 2, right? Seller warrants that the title is free of any liens, encumbrances, judgments, easements, assessments, bonds, restrictions, rights, conditions, or clouds on title, whether of record or not, excepting those noted above. So there's something to consider is just, hey, you know, what's actually going on with the property? Easements can be a real pain in the butt if you don't know about them, right? What's an easement? Does anyone know?
The neighbor and you have a line that is separating the property, allowing the utility companies to use it to get access, something like that.
Exactly right. Yeah. Another prime example is a shared driveway, right? If you've got a house behind your house and they have to use your driveway to get to it, guess what? That driveway is now an easement, right? So you can't block it because they can't get in and out of their house otherwise. Okay. Just an example. Okay. Number 3, seller warrants that there are no pending lawsuits, judgments, or claims against the property or against any person or entity having title interest in the property. Seller agrees to pay any such liens and judgments of which the buyer becomes aware, or in the event that the buyer is required to pay for these to perfect title, seller will be liable to reimburse buyer for buyer's reasonable expenses incurred in perfecting title. Make sense? I just don't want someone that's getting sued as my seller, and then all of a sudden the person that's suing them wins and says, hey, we want your house now too. Because that's where you got your most money. Okay. The amount of any secured loan, taxes, liens, bonds, assessments, judgments, other encumbrances against property not referenced above a buyer's option may be deducted from the cash down payment or subsequent cash payment. Okay, so it's saying that if there's any other liens that pop up, I'm going to take it out of your cash payment at the end. Ideally, I've left enough money at the end to make it worthwhile. Okay, what's next? Number 5, seller represents and warrants that he has disclosed all material facts, unfavorable information, or known defects which bear on the desirability, value, saleability of the property to the buyer in writing. Misrepresentation or withholding of any such information will, at the buyer's option, void this agreement. Right. So this is basically the one-liner disclaimer that's the equivalent of like an SPQ or TDS, right? SPQ stands for Seller Property Questionnaire. TDS is Transfer Disclosure Statement, which basically indicates whether you're under a flight path or if there was an old gas station at your property and you've got buried gas tanks, and or if you've got hazardous waste on your property because you used to have a mechanic shop running out of your garage, something like that. Make sense?
Yep.
Okay, number 6, contract and buyer's obligations they're subject to inspection and approval by the property by buyer. Counsel for buyer will not unreasonably withhold approval. It's just saying, hey, I could double check with my attorney on this stuff if I need to. Agreement is contingent upon approval of the buyer's attorney, right? In this case, I'm the buyer or my entity is. Buyer understands that this property may have one or more loans in default or nearly in default, which will have to be cured to perfect title and avoid auction at trustee's sale. Right? That's one of the key reasons for doing this contract or doing the deal, is because we're trying to avoid auction or foreclosure at a trustee sale. This agreement is contingent upon buyer's verification and subsequent approval of the condition of the title. Because defects in the title and the property can remain hidden, the seller agrees that at the buyer's option, the buyer may record a grant deed in favor of the seller, herein without liability, and or rescind this agreement. It's just saying we got to double check title. Sometimes it can take time. Typically, it's pretty fast. It's a 1 or 2 day turnaround. It can be more onerous in some parts, or if this is a property out of San Diego County where they have more written records instead of digital and filed, it can be more difficult. In places like Utah, it can take up to 28 days to get title because they have people run and do paper records and check paper files. Okay. Upon expiration of the cancellation period, or after 8 a.m. on the day of the trustee sale, whichever is sooner, seller agrees to execute and deliver signed notarized documents to buyer, including a valid and sufficient grant deed or warranty deed to the property, and authorizes buyer to record said documents, right? Once I record a grant deed saying that this buyer or the seller is transferring ownership to Covalum LLC, and I record it with the county, that's official. I'm now the owner of that property, regardless of what the loans are against it. If applicable, buyer shall deliver to seller a fully executed note and deed of trust containing the material terms and conditions set forth in paragraph 1E above, buyer shall cause the grant deed or warranty deed and the deed of trust to be recorded. Any original note, I don't know why Nate would be executed. Nope. Executed by buyer in favor of seller shall be delivered to seller, and the recorded deed of trust shall be returned to the seller. The grant deed or warranty deed to the property shall be delivered to buyer for the purpose of the agreement. Closing is to occur when these documents have been signed, notarized, and recorded. Okay. Possession. So possession of the property shall be delivered to the buyer, empty of the seller's personal property unless otherwise negotiated, and the premises vacated by the seller on or before whatever date we negotiated. Sometimes it's a month, sometimes it's 2, sometimes it's 6 months, right? I've had clients say, oh, can my son finish school? And that's not done for another 6 months. I'm like, absolutely. No one needs that kind of stress in their life. So I'll give them 6 months, but then I just adjust how much total consideration or cash we're paying them at the beginning of the contract, right? It's a little longer hold, but it builds good favor for us that, you know, we're treating them extra good. Okay. Buyer will withhold, right? And that's that same, that second number that in this case was $15,000 will withhold X amount from the funds due seller until timely possession of the premises in good order and repair, less the following amounts, right? This was kind of disclosed earlier, but I like to have this in there because I'm doubly stating it to them. Hey, if that lien turned out to be more than we thought, then I need to adjust my final payment. So the amount by which any lien referenced in item 1 exceeds the amount disclosed by the seller in this contract. So if the lien's higher, I'm paying you less. The amount of any lien not disclosed by the seller of this contract. A new child support lien shows up for $5,000. Guess what? I'm going to pay off that child support lien and pay you less. If seller does not deliver possession of the property to the buyer on or before, let's say it's 1 month, buyer may deduct from the amount of funds withheld provided herein an occupancy charge of X amount per day. It depends on the dollar amount, but and typically I'm charging about $200 a day, right? Because I want it to be enough where they say, crap, this is more expensive for me than just to go to a hotel to stay at my house. Sometimes I'll throw in a term if it's like a longer period. Hey, if you move out early, I'll pay you $100 a day extra to move out early, but I'm charging you $200 a day if you move out late. To give them a little incentive to say, okay, cool, I found a spot. Let me not drag my feet because it's costing me $100 a day. And that'll be an additional terms that I'll discuss at the end of this thing. Right, so if they're late, oh, I need 5 more days, no problem. It's only $200 a day. I'll just give you $1,000 less when you move out. Makes sense? It's in there. There's no grace period. I've already been nice. It's costing me money. I got to get this house moving. I had to delay my construction crew now. Okay. In the event the buyer and seller agree to a leaseback agreement, they shall enter into separate written lease agreement, right? And that says that if we're doing a leaseback, it's got to be someplace else. It's not on this document. Number 15, I rarely use this clause, but it's nice to have in there. Buyer reserves the right to show the property at any time prior to the date of possession between the hours of 8 and 9 p.m. Upon 24-hour notice, seller agrees to allow access to the buyer or his representative during this time. Okay, number 16, long paragraph that basically says that if the seller goes into a bankruptcy, they're not going to claim this property as part of the bankruptcy, especially if after they've already signed a grant deed to me, right? At that point, they got to know that they don't own the property anymore, even if they're living there, and you can't claim it on your bankruptcy court. We can always fix it, but it's a pain in the butt, and that means I have to get lawyers involved, and guess what? I'm going to take it out of what I owe you. So don't do that. Number 17, seller warrants that there is no real estate broker representing the seller in any way in this transaction and agrees to hold buyer harmless and free of any liability for any claims to commissions by any real estate broker as part of the sale, right? So it's just making you sure that you verify that, nope, you didn't sign a listing agreement with someone else and that I owe someone 5 or 6% on the sale of this thing. Make sense?
Mm-hmm.
Okay. Number 18, in bold and all caps, all parties are aware that the buyer is a real estate speculator and is buying the property for profit, gain, speculation, resale, and or development, and seller's net cash herein was fairly bargained for. Seller further understands that the current potential or future value of this property may be higher or lower than the purchase price above, and seller waives all claims to any potential or actual profits that may be realized by the buyer in connection with this property in the future. Does that make sense? Try to
Yep.
make it in as plain English as possible. Hey, I'm buying this home because I want to make money off of it. Okay. Seller acknowledges that the above purchase price is fair and equitable and is in seller's best interest. Seller declares that his decision to sell was based solely upon his own investigations of the alternatives available, and more specifically states the reason for accepting this offer are as follows. Got a blank here. We need the buyer or the seller to fill this in. What's the reason for selling this house to us? Anyone?
To prevent foreclosure?
Any other guesses?
Well, just stated clearly that they don't want the house anymore. They're leaving it, and instead of leaving it empty and vacant, they're turning it over or selling it to you.
Yeah. I mean,
LLC.
John is right. I just wanted to know if there's any other ideas, but every time the answer is to prevent foreclosure. That is the only reason that they're selling it to us. And it's a big reason, right? We know and we counsel and we teach people on the consequences of a foreclosure. We're preventing a foreclosure. We're cutting it close. You don't want to deal with the hassle of trying to list it, have 100 people through your house because you've already got 6 other adults, 4 other children, and 8 dogs living there. You can't be hassled with it. Make sense?
Yep.
So the seller themselves writes in here to prevent foreclosure. Okay. Number 20, buyer agrees to indemnify and hold seller harmless for any actual damages or loss that the seller may incur in the event the buyer fails to satisfy or cure any liens disclosed above, which liens are disclosed to and taken subject to by the buyer pursuant to paragraphs 1, 2, and 3 above. Such indemnity shall not extend to any credit reports or negative credit ratings received by seller and as a result of seller's defaults or late payments prior to the date of this agreement. Does that make sense?
You got to reread it.
Yep.
Yeah.
It's really a kind of get out of jail card for me and saying, hey, if something happens and I can't pay off these liens, you're not going to take it out on me. Knock on wood, I've never had to have that happen. Even the one where I lost a little bit of money on it, we paid it all off. Just got it done. I got to sleep at night and I'd like to have some integrity. So try to do the right thing.
Yep.
Seller warrants that all negotiations with buyer were at arm's length and that no undue influence or pressure of any kind entered the negotiation leading to this contract. Make sense? I'm not trying to strong arm you into agreeing to do this deal. We agreed on it fairly and it was fairly bargained for. Number 22, seller consents to the recordation of this contract and a memorandum of this contract and agrees to pay buyers necessary legal expenses in the event legal or other action is necessary to secure performance to enforce this contract, including but not limited to restitution of possessory rights to the buyer. Basically says that I can call a lawyer to force you to sign this contract if we're past the 5-day right of rescission period. If you've canceled prior to that, then no problem. That's fair. You're out of the contract. If you don't cancel before that time period is up, well, now you're obligated to sign this contract and sell the house. Any misrepresentation by the seller in this agreement shall, at the buyer's option, invalidate the agreement. Number 24. Buyer shall have the right to negotiate payoffs with any lien holders at amounts less than shown in this agreement without responsibility of any kind to the seller. So if someone's got a $10,000 medical collection and I'm able to negotiate down to $5,000 and I pay $5,000, well then I was able to negotiate that down. I don't owe that to the seller. Make sense?
Yeah.
Parties acknowledge that this agreement, together with any written addendums, constitutes the total and complete agreement between the buyer and seller, and that no oral agreements have been entered into, and all representations not set out are void and unenforceable. So basically saying, hey, what's written here is it. Don't tell me you told me this or you told me that. If it's not written on this piece of paperwork, nothing I might have told you is relevant. Okay? And I make people understand that, hey, if I said something and it's not written down here, let me know and I'll write it down here. But if it's not written down here, I can't hold any claim to that.
Yep.
Okay. Number 26, provisions of our agreement are agreed to in severalty by the undersigned, and invalidity or partial invalidity of any provisions of this agreement shall not render the remaining provisions invalid or unenforceable. Basically, if term X is not valid for some reason, it doesn't make the whole contract invalid. Okay.
Yep.
If any provision of this agreement is found by a court to be invalid, illegal, or overly broad, the parties agree that such provision shall be modified, right? We're going to change that agreement or that term, or stricken by the court to the minimum extent necessary to make it valid, legal and enforceable, and shall not affect the other provisions. Make sense? So if someone says, nope, we reviewed this and the court found that term 21 is invalid, we have to change it and make it more valid, and it doesn't invalidate the whole contract. The agreement is binding upon and shall inure to the benefit of heirs, executors, assigns, administrators, and successors of the parties. So if it's in probate and someone inherits it or someone passes away in the process, well, ideally the executor of the estate or whoever inherits the property would be subject to this contract as well. Time is of the essence. Number 28. 29, the language of this agreement shall be construed according to its fair meaning and not strictly for or against either party. It's gender neutral, as appropriate, singular or plural shall be interpreted to refer to the number consistent with the circumstances or context. Basically saying that, hey, if I say something's plural and it turns out to be singular, well, you get it.
Yeah.
Seller declares that his name above is his true and legal name and that he has been known by or has used no other names except the following. So if you've got any aliases or if you are divorced or recently married and you have other names on here or something like that that we need to put on there, that's where it's relevant. Typically, I'm doing like a statement of information anyways. It's a pretty extensive piece of paper that says what your names are, where you were born, your social security, every address you've had, et cetera, so that we can do a full title search and make sure that you are who you are, and that any liens or judgments that might pop up because you've got a common name can be excluded or included because it's either matching up with your addresses or not. Does that make sense?
Yep.
Okay. Buyer has advised seller that seller should consult his or her own legal advisor or attorney before entering into or consummating this agreement. Seller acknowledges by executing this agreement that seller has been advised of seller's right to consult with an attorney or legal advisor or seller's choice in connection with this transaction. Go talk to your lawyer, please. If you want to pay someone to review this with you, then by all means, I'm not going to stop you to do so. That would be wrong of me to do. Additional. So this is where if I said something verbally, oh, you've got all that stuff in the backyard, I wouldn't call it junk. I'd call it personal property. Hey, take anything you want and leave behind any personal property you don't. I'll clean up the house, right? Oftentimes, I'll do that where I'll give people the opportunity to leave all their stuff behind because they don't want to deal with it. They're moving into someplace smaller, and eventually if they're selling to me, they've eventually agreed that most of this stuff is junk anyways. Make sense? Okay, so that's kind of the additional terms. Rocio, can you think of any other additional terms we've used besides personal property?
What was the question?
Can you think of any other additional terms we've ever used on an EPA like this, equity purchase?
Just the personal property. If they're going to leave it, they should be able to dispose of it. I'm not sure if I don't remember if it's on there.
Yeah, sometimes I've had, like on Broadway when we did that, when they had like 2 or 3 dead cars in the backyard, they're like, we don't know how to get rid of this stuff. Can you take it? I'm like, I'll figure it out. I had to pay to get rid of them, but I took on abandoned cars in the backyard.
How about we're not responsible for putting any of it in storage for you?
Yeah, it's relevant, I guess, but basically it says that, anything. Yeah. Typically, if I take it, I think there's usually some paperwork that says that, hey, anything that's left in here is mine and I can do whatever I want with it.
Okay,
Right. Otherwise, I'm charging you your per diem because we
Yeah.
agreed that you were going to leave it, either leave the stuff and it's mine, or you're not leaving the stuff and it's trash, or it's clean, like that. Okay. This is your acceptance, buyer and seller, date, time, city, and state. Notice required by California law. Okay, this is part of Equity Purchase Act. It's Civil Code 1649 in California. You can look it up and see the exact text, but basically it says that I need to exactly have this on here because of all of the unscrupulous, quote unquote, investors and wholesalers in the past that would take advantage of unknowing sellers. The key component of that law was that a seller has 5 days to review it with family, friends, attorneys, any other advisors they want, whether this is a fair contract or not. And that's why they have that 5 days. So 5 business days. So they have these copies of these notice of cancellations. So if they say, yep, I changed my mind, I don't want to sell this house to you, I'm going to do something different. Well, then that's where they sign this, date it, and send it to me within 5 days. And I have to have this filled out. 12 midnight on the 5th business day after signing, or as of 8 a.m. on the date of the trustee sale. And apparently we're accepting telegrams as well. Okay. And it has to be in duplicate, so the same thing is in copy on here. And that's it. That's the whole contract. There's nothing more to it, but this is all that needs to get signed. Sometimes we do like the equity questionnaire. It's unfortunate that foreclosures have been gone so long that it's been a long time since we've done it. But at the same point, let me take a look and see if I can find it, because then that is just an additional document we make them do so they really understand what they're doing, right? So this is one. This is the house that I bought. This is actually the old address of the house that my parents live at now, where I went through this with the seller, and he was having some tough times, lost his job, chose a bad roommate. Maybe he was on drugs, maybe not, doesn't matter. But we bought this house, but I made him sign these paperworks so that we knew that he was sound mind, sound body. He understood what he was doing, right? Are you suffering from any kind of illness or taking any medication that could be possibly affecting your ability to make an informed decision? Yes or no? And they're initialing it. Have you at any time felt pressured or misled during the negotiation of the equity purchase agreement, purchase contract? Do you understand that title will be conveyed to Covalum LLC, the buyer, as part of the equity purchase contract, right? You are selling this house to me. You understand that the funds paid to you under the equity purchase agreement total, in this case, on our example, $400,000. Right? I'm sorry. In this case, the funds paid to you would be $25,000. Right? That's cash to the seller. The rest of it is payoff to the bank. So they understand, okay, I'm getting a total of $25,000, $10,000 up front, $15,000 later. Do you understand that the equity purchase contract is not a lease option to repurchase the property, right? This was something that unscrupulous investors would say is like, oh, I'll sell you back the property after I rescue you from your foreclosure, right? That's why these foreclosure rescue companies are scams, because they're literally there just to do what we're doing, but they're just not being honest about it. Okay, so we're not going to sell the house back to you. We're not going to lease it. Some people are like, oh, could I potentially? I'm like, possibly, but unless you come into a boatload of money, the bank isn't going to give you a mortgage anytime soon. Does that make sense?
Yeah.
So unless your rich uncle passes away and you inherit $1 million, it's unlikely. Do you feel that you have explored all other options available to you before deciding to enter into the equity purchase contract, right? And this is one of our key components of the training with us with distressed sellers, is that we review all the options with them, right? They've most likely tried and failed several times on getting a modification. Do you understand this is an equity purchase and not a mortgage or loan, right? I'm not giving you money. It's not a loan. This is me purchasing your home. Are you competent in both written and spoken English? If no, do you have a trusted translator? Right? Ideally, if we got to this point, I'd know by now if whether they spoke English or not.
Yeah.
Do you understand that Covalum LLC will be reinstating your mortgage, right? So they do understand that or they don't. If they don't, I explain it to them. Hey, you're behind $40,000 in your payments. I'm going to make that payment to the bank and make sure that the mortgage company doesn't foreclose on this property because after we sign all this paperwork, I'll be the owner. And I don't want to lose the house to the bank at that point. Do you feel that you've had sufficient time to consult family, friends, and or a professional regarding your decision? Do you understand that whoever it is was the licensed real estate agent who drew up this purchase contract and supervised the documentation and consummation of this transaction? Do you understand the title to the property will be deeded to Covalum LLC? Do you understand the terms of the equity purchase contract? And after answering this questionnaire, are you ready to proceed with the terms of the equity purchase contract? Make sense?
Mm-hmm.
So ideally, this is a little bit advanced. Ideally, you wouldn't have to be doing this, filling it out, getting the clients to sign it. That's my role. And so I'll still do that portion. But it's nice to be able to know it so you kind of are familiar with the terms. Hey, these are all the things that we cover, right? So when you're having conversations with them, you know what's going to be brought up.
Yep.
Questions, comments? Otherwise, we'll wrap it up. We'll take a little break before our 2 o'clock. Oh, I'm sorry, 3 o'clock. Yeah, 2 o'clock.
Quick question. Item number 12 on the contract. It's actually more of a thought than a question. So we talk here about where the amounts of a lien may be different than disclosed. Given the flow of the transaction from introduction to a foreclosed home to the discussions you have with them to get to this point, in the background, haven't we already, no, I'm sorry. So at what point, I guess before we've reached this point, we're going to sign an authorization with them to talk to their mortgage company to verify the numbers?
Yes.
So this is just a fail safe in the event that something else pops up.
Correct.
Gotcha. Thank you.
Yeah. So ideally, we have both a third-party mortgage authorization and a third-party general authorization. So we could do things like talk to their HOA or talk to their medical collections company. Got it?
Yeah.
Cool. Well, let's take 15 minutes and we'll reconvene at 2 o'clock for the project analysis spreadsheet training.
Okay.
All right. Thanks, guys.
Henish, are we supposed to submit the
Please, yeah, I'm sorry. Please do this contract. Fill it out. Just take up any property that we've sent you a list of, plug it in, fill out some generic numbers based on the training that you'll learn in the next hour, and send it back to me so I can, so that it tells me that you understand how to fill out these blanks and stuff.
All right.
So yeah, got a week for that. Please do that by the end of the week. That'd be useful. And then we'll go to the next trainings. All right, guys. Thank you.
Thanks.
Thank you.